laws.
Do you know what type of discrimination it is when someone is treated less favorably because of where he or she comes from? Or they have a particular accent or have a particular ethnic background? Do you see it listed here? If you picked national origin discrimination, you're right. And it also includes treating someone less favorably because of marriage or association with someone of a particular nationality.
Take a look at this list and pair up the definition with the types of discrimination. Employers may not pay unequal wages to men and women who perform jobs that require substantially equal skill, effort, and responsibility. The jobs do not need to be equal, but must be substantially equal. Which type of discrimination is this? If you picked pay discrimination, you're right. How about this? Employers may not discriminate against qualified individuals with disabilities in job application procedures, hiring, firing, advancement, compensation, job training, and other terms and conditions and privileges of employment. If you said disability discrimination, you're right.
Did you know that each year the EEOC receives thousands of discrimination charges? But you can protect yourself and your company from liability for discrimination by knowing and following the anti-discrimination laws.
Try this. Organizations may not treat employees or applicants more or less favorably because of their religious beliefs or practices, except to the extent that religious accommodations are required. Yeah, that's an easy one. Religious discrimination. Here's an example. An employer cannot refuse to hire someone of a certain religion or impose stricter promotion requirements on them. Employers can't impose more or different work requirements on an employee because of their religious beliefs or practices. Oh yeah, and employees can't be forced to participate or not participate in a religious activity as a condition of employment.
Learn the law and you'll avoid charges of religious discrimination.
Okay, that leaves one last one. Gender discrimination and sexual harassment. In an average year, the EEOC typically receives more than 12,000 charges of sexual harassment.
And nearly 15% of those charges are filed by males.
Sexual harassment is a form of sex discrimination. Unwelcome advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature constitutes sexual harassment when the conduct explicitly or implicitly affects an individual's employment, unreasonably interferes with an individual's work performance, or creates an intimidating, hostile, or offensive work environment.
As a manager or leader, maintain awareness and identify potential acts of discrimination and prevent behaviors that can lead to or can be interpreted as discrimination, and address them immediately. Don't wait.
Employers found guilty of discrimination can end up in court, be heavily fined, and in serious cases, the penalties and fines can be in the millions of dollars.
Believe me, you don't want that to happen.
You can avoid problems like that by knowing the EEO laws and applying discrimination-free practices throughout your organization. Base all employment decisions on the requirements of the job, not on the individual characteristics that are considered discriminatory. And review your practices to ensure they're not discriminatory, either intentionally or unintentionally.
Bottom line, employers who practice lawful and non-discriminatory employment decision-making avoid charges of discrimination.
It's time for the key points. The EEOC is responsible for enforcing a group of federal laws called the Equal Opportunity Laws. These laws were designed to protect people from discrimination. The EEOC can be involved with cases related to equal pay, sexual harassment and retaliation, and many others. It provides oversight, enforcement, and coordination of all federal EEO laws and regulations, practices, and policies. It conducts an investigation or facilitates mediation when a complaint is filed. The EEOC enforces a group of federal laws that prohibit discrimination against protected classes of individuals. Individuals are protected from discrimination on the basis of age, disability, national origin, pregnancy, race, color, religion, sex or gender, and genetic information. The first step in avoiding claims of discrimination or EEO investigations is to understand the laws and ensure that your organization is not violating them. You need to thoroughly understand the types of discrimination protected by federal law. Title VII prohibits not only intentional discrimination but also neutral job policies that disproportionately affect persons of a certain race, color, religion, sex, or national origin that are not related to the job and the needs of the business. This is called adverse impact. Adverse impact occurs when the employer has a policy or practice in place that results in substantially different treatment or selection rates for members of race, gender, or ethnic groups. Adverse impact can be intentional or unintentional, and in the eyes of the law, both are discrimination. Organizations may not treat employees or applicants more or less favorably because of their religious beliefs or practices. For instance, an employer cannot refuse to hire someone of a certain religion or impose stricter promotion requirements on them. Employers also can't impose more or different work requirements on an employee because of their religious beliefs or practices. And employees can't be forced to participate or not participate in a religious activity as a condition of employment. Employers found guilty of discrimination can end up in court, face liability, and incur the cost of enormous damage awards. In serious cases, the penalties and fines can be in the millions of dollars, especially when a manager is found to have intentionally discriminated against an employee or failed to take action when they knew discrimination or harassment had occurred. Take a minute to think about some of the employment decisions you've made over the last 6 months. Were they all based on requirements for the job and qualifications? And do you have any practices that might fall under the category of adverse impact and unintentional discrimination against certain groups in the application, selection, or hiring process? Examples might be promotions, new hires, transfers, where jobs are advertised or posted, or whether your job requirements discriminate in some way.
Okay, face it. Sometimes it's going to happen. Sometimes, somewhere, an employee or applicant is going to file an EEOC charge against your organization. Don't panic. We're going to talk you through it and show you how to deal with it. No need to be like those guys. Oh no, what are we going to do? Ever heard the phrase, cooler heads prevail? We're going to tell you how it works, what happens, and what you need to do. So keep your cool and let's get started. Be aware of time limits to file an EEOC charge. A person has 180 days to file a charge with the EEOC. EPA or Equal Pay Act suits must be filed within 2 years, or 3 years for willful violations of the alleged underpayment. In addition, the Lilly Ledbetter Fair Pay Act of 2009 says that the alleged underpayment may have happened years earlier, but plaintiffs won't be time-barred from filing a suit if they didn't know that the alleged underpayment occurred. Be sure to know what time limits apply to your company based on the state you're located in. The process when a charge has been filed. The EEOC will notify your organization that a charge has been filed and give you the contact information for the EEOC investigator.
The average time to process an EEOC investigation is 182 days. But a person can't just file a charge. They have to prove they were discriminated against and provide detailed information about dates, times, and witnesses. If you're notified by the EEOC of a charge, that means they've already deemed it a legitimate complaint that merits further investigation. But a charge doesn't mean your company is automatically found guilty of engaging in discrimination. It only means that the EEOC has decided to investigate it.
The EEOC assigns a priority rating to the case, with higher priority going to charges that appear to violate the law. There may be written requests for information, interviews with key players, review of documents. Documents are very important to your organization. Your documents can save you or sink you. Keeping detailed and consistent documentation is your best defense against any charges.